SJC-13072, in the matter of an impounded case.
Okay, Attorney O'Connor.
Thank you. Good morning, and may it please the court, Ann O'Connor on behalf of the child's mother. This court's decision in care and protection.
Could you bring the microphone a little closer to you? You're hard to hear.
Is that better?
Better.
Thank you. This court's decision in care and protection of Walt breathed new life into the requirement that DCF place a child in foster care only as a last resort. That decision changed an important aspect of practice in the juvenile courts in Massachusetts and benefited many children and families. In this case, the court has the opportunity to do more good for the most vulnerable families and children in Massachusetts, particularly families of color who are overrepresented in the child welfare system and suffer more than other children the particular harms that accrue from prolonged family separation.
Ms. O'Connor, can I ask you some practical parts of say you win, what does this look like? I know there was a motion filed in this case, and the judge thought, maybe appropriately so, that she didn't have discretion given the statutory language, but what's it going to take as far as the initial burden of proof to get a hearing? And I know you're going to argue, and probably rightfully so, that the department's always going to have the burden at the end of the day. But that initial burden to get either a hearing or before a judge, what's that going to look like in your world?
I think, as with any motion, it must be a well-pled motion. It must be a motion that alleges facts that, if true, would warrant a determination that DCF is failing to make reasonable efforts to reunify the family. If that is the case, then the court, most likely is going to entertain DCF's opposition to that. The court may decide the matter on the papers. The court may hear argument, or in some cases, the court may take evidence. But DCF agrees, all parties agree, that the ultimate burden of proof will be DCF's to prove by a fair preponderance that it has been making reasonable efforts to reunify the family.
And if we're going to have those hearings more often and we have more review, is it an abuse of discretion standard on review?
On appellate review?
Yes.
Sure, it would be an interlocutory order, so it would be reviewed under 231-118, and the standard is abuse of discretion or error of law.
And the other practical question I have for people that are in this business and do this, what's this going to do to the juvenile court's docket as far as, is it going to be counterproductive in such a way that the court can get through its docket now of CMP cases, and then this is going to be something that's going to take away from the ability to have the mandated hearings?
I can't imagine that it would ever be counterproductive to find out as early as possible whether or not a family is being given what it needs in order to reunify and to adjust if changes need to be made. In terms of, as a practical matter, motion practice happens in the juvenile courts every single day. Whether it's called a motion, as this one was, a motion for a determination of no reasonable efforts, whether it's a motion for increased parenting time, whether it's a motion to stop doing night-to-night placements for a child, but put the child in a stable placement. These motions happen every day. So we're going to maybe call them something different and be clearer about what the standards are. But I don't expect.
So I suppose, just to use a hypothetical, were a motion to be filed and then DCF answer to say, well, the parent is a no-show. They're saying they don't get enough services, but the parent has no-showed 3 successive times. The judge could then decide that on the papers.
Sure.
Correct?
Sure, absolutely.
And the last question I have for you has to do with the ability to handle this issue with respect to the abuse of discretion review. There's kind of a chicken and egg argument here. And I think the argument is being made that it's not an abuse of discretion because DCF has the obligation, of course, right? Constitutional obligation to make reasonable efforts and statutory obligation to make reasonable efforts. But DCF also has the discretion to decide how to implement services, correct? So help me wrap my arms around that chicken and egg issue about abuse of discretion and why it shouldn't apply and cover this situation.
Sure. So the legislature has determined that it is for the courts. The judge is the arbiter of whether DCF is making reasonable efforts. That's a fact determination that the judge isn't just authorized to make, the judge is required to make. So the question isn't.
So then there's a service plan, right, by DCF?
Yes.
And they set out the steps, correct?
Right. I'm sorry, I lost my train.
And that's my fault. I apologize for doing that to you.
I was going to make a really good point, too.
It
was the winning point, the winning point.
Right, I'm sure you're rally.
So the question before the court would be whether DCF's, what DCF is doing, whether it's services and other assistance, is reasonably targeted to alleviate the problems that necessitated the family separation.
Yes.
So for example, we have cases where, we have appellate cases where DCF required the parent to do a substance use disorder evaluation, and there was no indication in the record that the parent ever had a substance use problem. So on appeal, that was deemed not, failure to comply was something that shouldn't be held against the parent. So services that are not designed to remedy the problem so that the family can be reunified really are no good, right? We need services that are designed to address the underlying problem.
Right, so that's what I was trying to get at, and I apologize again for distracting.
Yeah, I'm going to cut you off before you get your next brilliant idea. So
I wasn't done asking the question, but go ahead.
Oh, no, go ahead.
So can you get back to the whole chicken and egg issue about where does discretion start and end, and why the abuse of discretion review is completely inadequate?
DCF has discretion to, DCF is required by law, first of all, to work with the parent from the start. DCF is not supposed to design a service plan and give it to the parent and say, here you go. DCF is required by law to sit down with the parent and together figure out what services are best for the client. So if that happened in more cases at the start, then probably a lot of these issues would not arise. But so DCF designs a service plan. DCF says you get to see your child, your 3-year-old child, once a month in person. So you get one visit, and you get to see the child 3 times a month over Zoom. I think a judge could reasonably say, and I think this court would say, as it did in Care and Protection of Walt, that providing parenting time that is insufficient to protect the parent-child attachment that is essential to reunification is a failure to make reasonable efforts. So DCF has discretion to set out the parenting time plan, but if it is insufficient to maintain that bond, it is per se a lack of reasonable efforts. They didn't abuse their discretion. They violated their legal duty to make reasonable efforts.
You've answered my question. Thank you.
Thank you.
Can I ask a variation on Justice Gaziano's question? So these reasonable effort determinations they're big motions. They're a sort of a totality of the circumstances. We look at everything, right? It's not targeted towards, okay, they didn't provide a good visitation. It looks at the overall reasonable efforts, right? It's not an individualized motion, right?
Maybe I'm not understanding what you mean by individualized, but they will ordinarily.
Let me give you an example. Okay. So there are 2 different kinds of motions. In the appeals court, they talk about these abuse of discretion motions, or what do they call they're the ones targeted towards, more specific failures, not the global efforts, but the visitation wasn't done the way we agreed to, right? We have lots of those kinds of motions, right?
You have
the daily practice at DCF, in courts.
All right.
Because what I'm asking, and let me finish I'll put it all together for you. Does the judge have discretion to treat this as either a reasonable efforts determination that requires sort of a totality of the circumstances and the services being provided, or say, now this is just an ordinary abuse of discretion motion. We're really focused on individualized services here, and that's a classic abuse of discretion issue, so that the judge can make a determination how to treat this motion. You can't, as the lawyer, dictate how it's going to be evaluated.
Well, if you bring a motion under 29C for a determination of reasonable efforts, then that, and that's what you plead, and that's what,
Yeah, but just because you call it that doesn't mean that's really what it's about.
Sure,
It
but
may
if-
be more targeted towards an individual service problem, which is I mean, having done this for 20 years, there's a lot of fighting about little things. And that's a less burdensome task for the court. And I just wonder whether the court has an ability to say, this is an abuse of discretion motion versus this is a overall reasonable efforts.
So I think it may help to kind of start at the beginning. In 1995, this court issued two decisions, care and protection of Jeremy and care and protection of Isaac. Care and protection of Jeremy was a situation where there was a dispute between parents and the department, and maybe perhaps the child, around which of two particular residential placements was better for the child. And the judge picked, the trial court judge picked. In Jeremy, the child was in the department's temporary custody. After a temporary custody hearing, there had been no trial, no hearing on the merits. So that's where we are procedurally in our case as well. In Isaac, the child already had been adjudicated to be in need of care and protection, was in DCF's permanent custody under Section 26, and it was the same thing. There was a dispute. I think the child's GAL wanted a particular placement, the department wanted another one, largely because of funding issues. So this court decided and held that in a situation where there's a dispute among parties about a particular residential placement for a child, DCF had discretion to make that decision, and that decision was reviewable by a court only for abuse of discretion. Those are the holdings. They're pretty limited. And
Yeah,
the
but
court,
we have guidance. West gives you an example. There are a bunch of motions that we just look at as abuse of discretion motions, right? And I'm just worried that if you combine these two, if you make every time that you decide to bring it as a reasonable efforts claim, anytime there's a deficiency in anything they're doing,
okay.
we're going to end up having what Justice Gaziano describes as, a bottleneck of, cases in there.
Okay.
So can a judge decide, no, this is just an ordinary fight about one particular service. I'm not doing this reasonable effort stuff.
If it is a fight about one particular service, if my motion says, I want you to decide DCF's not making reasonable efforts because DCF won't give me family therapy because I refuse to do individual therapy first, and it's a prerequisite, but I don't like individual therapy, I only want to go to family therapy. That's not, that's a motion that's going to be denied.
Can the judge also decide, just because you throw in a couple of things, still doesn't make it a reasonable efforts issue? It's really, the judge gets to decide what kind of motion this is, not what you put a label on it.
I would say that the motion that I just suggested would be just denied, right? That's not, it wouldn't be, is DCF abusing, it would just be denied, because that is not a motion that is, alleges facts that, if true, would warrant a determination of no reasonable efforts. So I think that motion's denied. This idea that everything is an abuse of discretion motion came from this fallacy that when this court said that in the limited circumstances of Jeremy and Isaac, the standard of review was limited to abuse of discretion, that became, everyone just presumed it applied to everything DCF did, and those cases don't apply to that. So that practice, absolutely, Your Honor, that practice has been in effect, I would say, since about 1996 until about 10 years ago, when people started really relooking at those cases and asserting other bases for relief and other standards of review for those. So I think, yes, on a motion that does not plead a case for no reasonable efforts determination, that motion is fairly denied. And we look at then reasonable efforts. And I don't think that a reasonable efforts determination requires this all-encompassing evaluation of everything that's happened, because the pleadings will go to particular facts. You know, the department's let me see my child 4 times in the last, 10 months. The department signed me up for 4 services, all of which have wait lists from 3 months to 7 months. The department says there's nothing more they can do for me. I'm just going to have to wait. We can't wait in these cases. Time is of the essence. This court has said no cases of any kind have a greater claim for expedition at all stages than those involving the custody of children. And when it comes to is DCF making reasonable efforts, time is of the essence. We have to get to that problem, fix it early so that everyone has a fair opportunity. The parents and the child are given a fair opportunity to be reunited, because there's no question. You've seen the data that the amici have submitted. Foster care is generally bad for kids. It's sometimes necessary, but if it's necessary, let's end it as quickly as we can. That's the mandate. That's the whole idea around the reasonable efforts requirement. And that's something that this Commonwealth has recognized since 1954.
Thank you. Thank you so much, Attorney O'Connor. We'll hear from Attorney Comeau.
Thank you.
Good morning, Your Honors. May it please the Court. Attorney William Comeau, representing the appellant child. I had a great opening that I wanted to do, but I wanted to make sure I got an opportunity to address some of the questions that were already asked. First of all, concerning the issue of whether the courts will be bottlenecked, I would suggest to this court that the courts are bottlenecked now. There are over 40,000 children in foster care in the state, and I've been doing this for about 30 years. The courts are extremely backed up in getting these matters addressed to trial. There are cases in my county that are over 4 years old. These matters are supposed to be resolved within 18 months at the most. And the reason that they're backed up is because the courts don't really have the authority under the current law to address issues of reasonable efforts by the department in a timely manner. If they were given that authority, the department would be more incentivized to collaborate with counsel, with parents and children, and they would have the opportunity, because of that collaboration, to form a path forward for the parents and children. Right now, that does not happen in the juvenile court system. Or if it does, certainly I can't generalize, I only practice in one county, but it certainly doesn't happen very frequently. The issue...
Counsel, you said if they were given that authority, isn't your position that they already have it?
It's my position that they do have it, they're just not exercising it. And that's because of the issue with this abuse of discretion language. Attorneys don't file abuse of discretion motions because the standard is so high, it's almost impossible for them to get a result. Arbitrary and capricious is just like saying, unless the department did something completely idiotic, we're not touching this. That's the feedback that attorneys get. And so motions don't get filed. Mm-hmm. If there's an issue with the way that a case is progressing, you have to wait either for a permanency hearing after a year or for trial after 2 or 3 or 4 years before you can even get a decision from the court as to how that issue should have been resolved. It seems to make sense that a much simpler, straightforward way of addressing these issues is asking the court at the beginning of the case, if you have a problem with, for instance, what the department is doing, what service it's providing, or whether it's not providing a service that you feel that your client needs, ask the court to determine whether that service or that recommendation, that issue, is a reasonable effort on the department's part or not.
Well, you have at least one opportunity before the annual review. You have it at the 72-hour hearing, right?
No, Your Honor, you don't. Normally, oftentimes, there are no service plans even in place at the 72-hour hearing. Oftentimes, the department will remove a child and then develop a service plan within 45 to 55 days.
So that you're saying that not only should they be done, but that the first two are just silly. Is that what you're saying?
Sorry, I couldn't hear
The
you.
first two opportunities, which are when the child is taken away and at the 72-hour hearing, the legislature just drafted it in a silly way.
No, not at all. It's a different focus. At the removal and at the 72-hour hearing, the focus is on reasonable efforts to keep the family intact.
Right.
And so after that, at the permanency hearing under Walt, at the permanency hearing at the trial, the question is reasonable efforts to reunify the family. So it's two different things. They're generally, prior to the removal, oftentimes anyway, not always.
So but there are no, in your view, there are no limitations after, basically you could file it every week, right?
No, not at all.
So
No,
what are the
I think attorneys
limitations?
have responsibilities to understand what reasonable efforts means. It doesn't mean that you simply disagree with what the department's doing.
Right, so does that mean you have the ability to make one challenge on in the middle of the year at 6 months? I'm just trying to understand what, you obviously get to look back at the end of the year at the 119 provision, right?
Yes.
So I guess, is one enough? Or, I mean, I'm just confused about how often you're going to be able to file these things, because this is a very vigorously litigated area of the law.
Yes.
So I'm just trying to understand what do you want us to say, that whenever, you're entitled to this? Because the statute says not less than once a year, right?
That's right.
So you're saying what?
Yeah, I guess the issue is, what's your initial burden?
I'm sorry, Your Honor.
What's your initial burden?
The initial burden would be to present a motion which suggests to the court and explaining why that the department failed to use a reasonable effort. And obviously, a reasonable effort.
It's reasonable effort to reunify.
To reunify, yes, excuse me. And that involves the court assessing what is reasonable, because this court under Walt gave the juvenile court the authority to determine what is reasonable.
And do you agree with Ms. O'Connor that could be something the judge could decide on the papers?
Oh, absolutely. Generally, I believe it would be. And that's because you would do the legwork ahead of time in order to prepare your case for the court. You don't simply walk into court and say, the department's not doing this, I'd like them to do that. You communicate with the department. You try to collaborate with the department. You make efforts to explain to them why you believe this is the best approach. The department certainly has discretion to choose among services how to fulfill its mandate. And I don't believe a reasonable efforts motion involves that.
And just, if you could educate me, for someone who's been doing it for 30 years, how much collaboration is there with the department, and how does that go on an informal basis?
I'm sorry, Judge, because of the air conditioning or whatever this is, I'm having a hard time hearing.
Yeah, how much, from your experience doing this for 30 years, how much collaboration is there with the department regarding service plans, and does that happen informally, and is that something that we should take into account?
Yes, service plans, in my experience, are not developed collaboratively. Normally what will happen is the department will, at some point, forward a service plan to the client. They may or may not send it to the attorney. The client will then have the opportunity to review it. If you have any concerns about it, you would then contact the department. But there's no discussion. There's no collaboration going on.
A loaded question.
Yes.
Do you think that the ability to file these motions would lead to more collaboration?
Absolutely. Absolutely. Because that way the department understands that it's not an abuse of discretion standard, and they're basically scot-free to do what they like if it's an abuse of discretion standard, because the standard is so difficult for attorneys to obtain. And so if there is a court reviewing the department's involvement, all for the best interest of these young children who are in foster care, then yes, the department will be incentivized to collaborate. And I understand from the public hearings the other day that they're looking forward to collaborating with attorneys on these matters. So I would think that it's a win-win for everybody.
You may want to end with that hanging curveball.
Thank you, Your Honor.
I think that's a really good piece of advice. We're going to look to Attorney Bayless to explain to us why this isn't a good idea.
May it please the court, Jeremy Bayless for the Department of Children and Families. I apologize if I'm too tall for the microphone. I want to start by addressing sort of a fundamentally flawed underpinning of both my brother and sister's cases, and that's the idea that the only way to review the provision of services is through a reasonable efforts determination. That is fundamentally untrue. From the time the department takes custody of a child, there are both informal, or I guess more administrative methods of review. There's monthly meetings with the social worker. There's foster care review meetings held every 6 months. Parents have the ability to negotiate service plans, and I know that when I was an attorney at CPCS, that's what I did. Parents have the ability to reject a service plan that they feel does not provide services that are necessary. They can file a grievance on that decision if they continue.
Are these in any regulations or any practice we can look at?
In the department's briefs, they've also been recognized by the appeals court in West. I lay out the citations to it in my own brief as well. If the grievance doesn't go the way they want, they have the ability under Chapter 30A to appeal from that decision to a justice of the Superior Court.
That's a longer process, though, right?
It certainly is, yes.
I mean, we're talking about bonding with a child and having done 30As from brought by parents. I can tell you that they're not going to take three months.
I agree. That may not be the most efficient route for a more urgent method, but it is an option. Moving to the appeals court, moving to the juvenile court itself, there's the ability at any time to file an abuse of discretion motion.
Okay, so now we're talking about the chicken and egg conundrum.
Yes.
That I talked about, because obviously the vast difference between the motion brought in this case and what you propose as a solution is the burden of proof, correct?
Yes, Your Honor. And I think that, in fact, this case is probably more illustrative than some of the anecdotal evidence is provided by my brother and sister, because if you look at the way that this case below was handled, the department's attorney, after taking custody and before the 72-hour hearing, immediately reached out to try and coordinate and work collaboratively, and that email's in the record. And then 2 months later, she reached out again after receiving no response, saying, we need to meet on this, we need to work together. Again, nothing happened. Nothing happened for a good 4 months till June. And then there's further, I don't want to get too much into the back and forth on the communications, but the record shows that there was an attempt to be collaborative. It wasn't particularly productive for reasons that I think are clear in the text of the emails, but I'll sort of leave it there because there were no findings on that point. It didn't get to that level.
And I understand the merits argument, but this case, really what we're searching for is the legal proposition where an experienced juvenile court judge says, I don't have the discretion to do this. So we have to answer the legal question about whether or not the judge did have the discretion to hold one of these hearings.
And the department's position is that she did not. And that was because the legislature...
But statutorily, it just says no less than, right? So the statute doesn't answer that question, does it?
The statute in the narrow reading just of 29C doesn't expressly answer it. But when you look at B and C together, the legislature laid out a series of specified times for reasonable efforts determinations. That creates a...
But as counsel points out, the first two have really nothing to do with reunification. The first two have to do with removal.
Yes, they do.
All right, so then the only reunification under the statute, reasonable efforts towards reunification, is at the annual review in the permanency hearings?
It is set out as not less than annually. As my sister points out in her brief, and we agree, those can actually be sought earlier or advanced at the motion of either party. So the concern, the department's...
I guess I'm confused because I thought the legal question was whether or not the juvenile court judge had the authority to hold one, and I take from your last answer that was yes, she did have the authority.
Not exactly. I realize it's a bit of a fine point.
Well, I mean, before you said no, now you say yes, so yes, please
Right.
explain.
Yeah, we're putting different labels on these
difference
hearings.
between a freestanding motion for reasonable efforts determination that my brother and sister seek to have resolved in a summary fashion by a judge, and requesting a permanency hearing, which necessitates, as my sister pointed out, and I do in my brief as well, an evaluation of the department's plan. The department's position is that reasonable efforts determinations, as all the literature lays out, is a large-scale analysis of the department's efforts towards reunification. It's not intended to be, you gave me a visitation or a parenting time schedule I don't like.
That's the point that Justice Kafker
Yes.
ably pointed out, that we're not talking about
And so,
the minutia of it, we're talking about the totality, correct?
yes, Your Honor. And so, therefore.
But the
because this
burden
is-
would be on the moving party to say, based upon this totality, the reunification service plan is not up to snuff, correct?
I'm sorry, did you say that just the court at the beginning?
Yeah.
Yes, I believe that would be correct.
But wouldn't the judge be able to look at that and say, I need to look into this, or no, it seems fine to me, and deny it on the papers?
I think that as were these motions that are novel, they've not been done in the Commonwealth before, were they to be adopted, I agree that a judge could dismiss one that was improperly pled summarily. That's not really, I think, the relevant inquiry to the impact on the caseloads. If they do a bad job pleading the motion, fine. The problem is what happens when you get a case where it's not poorly pled and it is a complex issue. A parent alleges now after 9 months that they no longer speak English and need an interpreter when there's been evidence, and there has to be a determination as to whether or not, as to who made the mistake. That type of analysis is a bigger picture, and that alone.
But given the stakes involved, I mean, I guess I'm trying to figure out why that, just because it's complicated doesn't mean it's not worthwhile. And the statute says at least once a year. It doesn't say only once a year or only in connection with the permanency hearing.
But it absolutely is worthwhile to do, but it's worthwhile to do at the times that it's provided for. And the
But
fact
yeah,
that
that's the question. When is it, why is it your position that it's only provided for annually or coupled with a permanency hearing? Where is that in the statute?
it's the statute. We wouldn't be here if the statute expressly said that it is only at the times that are specified, or if the
But that
statute
seems to be your
expressly said-
position. Is that, what is the basis for that position?
Because the legislature has demonstrated that it is able to note when it intends for there to be a separate right of action. As an example, you can look to 11939D, the grandparent visitation statute. It expressly states in the second paragraph, a petition pursuant to this statute may be or must be filed, and then it gives some jurisdictional restrictions. The legislature has the ability to specify when it wants there to be motion practice on a topic versus when it wants there to be a hearing determination, when it wants there to be a determination made at a hearing which encompasses, by its definition, the sort of wholesale analysis that is necessary to provide the context.
Why didn't they use not more than?
Yeah.
I mean, if, in your view, it seems like they could have made that all go away by saying not more than once a year. But they don't. They say not less than, and it just seems weird for them to do it that way. What if the judge had the ability to decide for herself that this is a reasonable efforts determination because it's a big issue and I think it's reasonably presented, or to treat it as, you know, one of the little ones that she uses the abuse of discretion standard? Why does that harm the Commonwealth? You leave it to the judge, because the judge is the one who's going to have to do all the extra work here too. They don't have any incentive to do this on little cases, do they?
Assuming that it is adopted under Your Honor's interpretation where abuse of discretion motions still exist, my sister argues they should not.
I don't think we're going to say that you can't treat this as, I just think we're concerned that if this really is a reasonable efforts case, that it can't wait a year. But if it's just if they're just fighting over particular services, then the judge still has the right to say that's a discretionary call for DCF. I just don't see why you would oppose that, given the statutory language.
I think the simplest answer to that is if there is one motion that is a challenge to the department's provision of services that is reviewed by an abuse of discretion standard. And then there is another motion that is a challenge to the department's provision of services, but big picture. In that one, the department has the burden of proof by preponderance of the evidence that it has made reasonable efforts. You are creating a perverse incentive for attorneys not to use the first motion when they first become aware of a problem. If, for example, you have an initial meeting, or in this case, COVID happens, visitation goes from in-person to Zoom.
Right.
The attorney can wait or can file an abuse of discretion motion on that issue. Or the attorney can do nothing for several more months and then accumulate alleged infractions, then file a motion for a reasonable efforts determination.
If we provide definition of what it takes to raise questions about reasonable efforts, so that, okay, these kinds of things don't rise to the reasonable effort. We're expecting a lot more from judges on a reasonable efforts determination. They've got to make findings, they've got to look at the whole picture, and we say, okay, that's raised by these kinds of conditions. I don't know if we can do that, but that would provide some definition so that we're not just picking and choosing arbitrarily between abuse of discretion motions and reasonable efforts, because obviously Mr. Comeau is going to file for the bigger one each time, and you're going to say it's the little one. But
and I think that's why the legislature attached those reasonable efforts determinations when it chose to expressly say when they should be made to hearings where it's already happening.
Not less than. They didn't give us any definition.
But
They didn't
look
say
at when they did tell us.
expressly. They didn't say expressly, but I want to move just for a second, if I could, step back from what not less than annually means and go back to where you started. Because everyone has the same concern here, which is what's the systemic impact on the juvenile court, because everyone's concerned how long the care and protection process is going to take. And what we're hearing from parents and child is, well, if we have this collaboration early, systemically, this is actually going to move the docket. This is a great case flow management issue, which is terrific because we'll have resolution and not have these kids hanging in the balance for so long. And you're suggesting, well, if it's that easy to have these type of evidentiary hearings that are the bigger type of hearings that we've been going back and forth on, that these juvenile court judges without enough law clerks, overburdened, and it's hard to go through and make these findings, it's going to slow everything down. My question is, that's a huge, huge issue. How are we supposed to resolve that? How do we know which one's right? We can't survey the juvenile court judges. We can't do some sort of survey of lawyers. How are we going to resolve the implications?
We have to look, I guess, to the setup that is currently existing. I think everyone agrees that there is, at least to some extent, a backlog in the juvenile courts. The clog happens. And whether or not having unscheduled evidentiary hearings, because I don't think it's possible to sync the rhetoric and the language that comes from the description of reasonable efforts with summary motion practice. I think that by its nature, it needs to be a deeper analysis so long as it's adequately pled. And so we currently have those happening at scheduled hearings. And this would be adding the opportunity for there to be additional hearings. I think the parties mostly agree that the answer to question one, is it mandatory that it happen, should be no. Because if they're mandatory evidentiary hearings, that would be the worst case scenario for the juvenile court's docket, because it would eliminate their ability not to go into that, not to have an evidentiary hearing when it doesn't work. So if you want to maximize the efficiency of addressing problems with services, the problem needs to be raised the first time that it becomes clear that there is a problem with a service, not a couple months later, when there's several services, there's a problem, and you can put it together in the idea that the department has failed to make reasonable efforts to reunify the family. The problem with visitation or parenting time needs to be raised when it becomes aware that there's a problem with visitation and parenting time, which gets back to Justice Kafker's point that those individual services complaints are not appropriate for reasonable efforts. So the abuse of discretion process is designed around the idea that a complaining or I guess aggrieved parent or child raises individually as soon as they are aware of a problem with service provision. That brings it to the department's attention. It brings it to the judge's attention early, and if the and it allows it to be resolved in the most expeditious way. The reasonable efforts for it to be a wholesale abdication or failure to work towards reunification inherently requires more than that, which means there needs to have been an accumulation of flaws.
Counsel, I don't mean to interrupt your point, but I just want to, don't we trust our trial judges a little bit more than you're suggesting here? I mean, don't the juvenile court judges have an opportunity to look at these pleadings and make a determination as to whether or not they're individual service complaints that are being couched in the reasonable efforts kind of motion, and be able to then say, this does not warrant a full-scale hearing, and all of the things that Justice Gaziano talked about? That don't we trust our trial judges just a little bit more to be able to divine what this really is versus what it's not?
They certainly do have yes, Your Honor. The short answer is yes. They have the capacity to determine on the pleadings whether or not this is a misfiled or mistitled abuse of discretion motion, or they're alleging something else. My point to Justice Lowy is that if it is a reasonable efforts challenge, it is outside of the scheduled hearings, then it is necessarily an indication of multiple complaints that could have and should have been raised earlier in a way that would bring that to the attention. If the goal is to fix these problems fast, don't accumulate them, raise them as soon as you're aware, and that would not fit the way that we've been discussing reasonable efforts determinations.
Can't it be a both and?
I'm sorry, Your Honor?
Can't you do both?
Right.
If you've
Sure.
raised the issue and it wasn't resolved, continued to raise the issue and it wasn't resolved, shouldn't you have the opportunity to go to the juvenile court and say, we've raised the issue, here they are, we'd like the judge to resolve it?
And if the department has not been abusing its discretion and there is merely a dissatisfaction with the provision, then that would indicate that there hasn't, sort of by definition. I understand there's points, as my sister raised, where that would be in more tension. But there's a mechanism under the system that's already in place for that. The parent has the ability to advance the permanency hearing, which would then involve the type of analysis of the department's plan that provides the context to determine what is or isn't reasonable towards achieving that plan, because as 29C and B point out, reasonable efforts at a certain point can change from reasonable efforts to promote reunification to reasonable efforts to promote permanency if the plan is such that efforts to reunify would be contrary to the achievement of that goal. So the current system, without creating an independent freestanding motion for a reasonable efforts determination, which has never been utilized in the Commonwealth before, already accounts for that outlier situation and provides parents an avenue for relief. It just does so in a way that provides the necessary context to make an informed decision.
Okay, thank you.
Thank you,
We'll
Your
take
Honor.
our morning break at this time.